Good morning, ladies and gentlemen. Dear colleagues, many friends from the Collective Redress, small but steadily growing world. It's my privilege to share a view from the front lines, as Steve Idrod suggested me yesterday, this title, to open this 2 days Global Class Actions Symposium organized by GLG. We are more than 200 experts from around the world to have registered. And although giving a keynote speech is still an impressive exercise to me with this audience, I did not hesitate a second. Aside from the fact that Lisbon is a very charming city, the conference takes place at a meaningful place and at a meaningful time. A meaningful place, since Portugal is undoubtedly one of the most important hubs in Europe, sharing the podium with the Netherlands and the UK. I can bear witness to that, as I'm the president of US Omnibus, a Portuguese-based European consumer association, having brought more than 50 popular actions since 2020. And I'm the board member of a Dutch foundation, Stichting, a special purpose vehicle bringing diesel-related cases in the Netherlands, France, and Belgium. But the time is also meaningful, since recent changes in our world, in the collective redress world, are profound. Class actions are no longer exclusive to common law countries. They have landed in our civil law jurisdictions within Latin America, Africa, and Far East. They have even been adopted by the European Union, quashing the myth, the Sisyphus myth. Last class actions are a legal construct that are neither in their infancy nor in their youth. They are mature. They are established institutions in their fuselage, we would say in French. Therefore, let's draft together their memoir, their memories. It's important to know where we come from, to understand where we are. This is what I would do in a second time, and try, if time allows, to draft some global perspectives, so past, present, and future. So let's start by drafting together what would it be like to have the class actions in the world memoir. Of course, the statement that class actions are globally established supposes that we agree that they were born in 1966 with the reform of the opt-out rule, the Rule 23 of the Federal Rules of Civil Procedure, adopting the opt-out default rule, aside from setting out structuring categories. By then, behavioral insights had suggested that the low percentage of members of the class expressing their interest to opt-in because of the opt-in rule that had pre-existed could turn into an equivalent percentage of members of the class expressing their will to opt out if we adopted the default opt-out rule. The reform were then under the radars. It was considered as a scholar's reform, and it fashioned what we now know as the American way of law, prioritizing and encouraging private enforcement. This period also witnessed the growth of contingency fee agreements. Thus, these two components, opt-out plus incentives for lawyers, gave rise to class actions in consumer rights, securities fraud, but also to address widespread harms, maximizing participation and impact. Afterwards, our memories should encounter that other countries began formally adopting class actions. First Canada with Quebec, Ontario and British Columbia, again with similarities, the opt-out, and stronger emphasis on the social dimension to avoid frivolous claims, sweetheart or blackmail settlements. Australia also introduced representative actions in 1992, again with an opt-out mechanism and a different approach to incentives, because there was an early positive approach to third-party funding. loyal to the common law tradition, and we say in Latin, ubi remedium ibi jus, where there is a remedy, there is a right, these common law countries granted a procedural remedy to acknowledge substantive rights to subjects. These developments could insinuate that the dynamics of case law proper to common law countries fosters developments of class actions, and this statement could be considered as confirmed by the leading role of the UK today with the general litigation order, the competition, collective action, and the representative actions. But at the same time, a lot was going on in the civil law countries, loyal to their principle according to which ibi jus, ibi remedium, where there's a remedy, where there's a right, there's a remedy. Civil law countries started acknowledging substantive rights. In the old European continent, the cradle of civil law traditions, the development of consumer law materialized through dozens of directives and regulations. They were intended to give confidence to consumers so that they can buy everywhere, knowing that they will be protected the same. And as my dear Professor Samuel Sakharov explains or exclaims every time he comes to Europe, another European text, what for if there's no enforcement? So far, the only means for enforcement was the Injunctions Directive adopted in 1998 and amended in 2009, but there was no compensatory relief. And it has been a topic, a hot topic for more than 20 years. We have seen a green paper in 2007, a white paper in 2008, a resolution for a coherent system in 2012, and an important recommendation of the European Commission in 2013. But a fitness check run by the European Commission in 2018 revealed on the one hand that 9 member states were still lacking of a compensatory relief. I participated in that study, and I would say there were far more than 9 member states, because those that had a collective redress mechanism were not efficient. It also revealed, that fitness check, that there were gaps and inconsistencies when it comes to cross-border collective actions. But that fitness check was instrumental for the adoption of the Omnibus Directive, which strengthened public enforcement, granted the national public authorities to impose fines up to 4% of the annual turnover of a company in case of serious breach of European Union consumer law. And the second one, the Representative Actions Directive, imposing all member states to adopt a collective redress device, both with injunctive and compensatory relief. This was a landmark shift toward greater consumer empowerment. But again, these memoirs should encounter Latin American countries and other continents. A lot was going on in Brazil, that adopted the Consumer Code in 1990, and in Argentina, that adopted the Consumer Protection Act in 1993, followed by an important reform of the Constitution, granted consumer rights a constitutional standard, and something that we call in our countries amparo collective, a procedural mechanism to enforce constitutional rights. And that has been seen, or can be considered, as an implicit recognition of class actions that had triggered an important, though chaotic, developments that I experienced by then as legal director of a national consumer association. Today, more than 50 countries have adopted modern forms of class actions, and others should follow. And to wrap up these partial and sampling memoirs of class actions around the world, mixed systems also have adopted class actions. We can think of South Africa with case law developments in the aftermath of constitutional roots for their rights, or Israel, 2006 by law, and the case law is, as we all know, prominent both because of the high rate of lawyers per capita and because of the perceived, the positive perception that judges have of this social and public interest mechanism, the class action. And yet, if we wrote now the story of class actions around the world in a nutshell, it's because as nations, I believe an institution that forgets her past has no future. Let's see now what we've learned with the many hats I wear. It's been recalled that I'm a professor, that I advise lawyers, many American lawyers, by the way, and that I founded the Observatory of Group Actions. So let's share some data and statistics. Because class actions frameworks have developed uniquely around the world, but they have been influenced by local traditions and by policy priorities. So the first lesson learned is that the well-established contrast between the American way of law encouraging public enforcement still contrasts with the European manner based on public enforcement. The countries that I forecasted in the first part show the importance, the significance of political choices that transpire through provisions of our regimes. Last week I was reading my press in the morning, and I read about the Yahoo settlement in the data breach cases, and the same day in France, a French company was announcing a leak in data, and the latter was just apologizing whilst the former was concluding a settlement. But these two opposed systems, European ones, common law systems, are currently tending towards much closer developments than they appear. For instance, in the Dieselgate, it seems to be that the role the public enforcement, the EPA had, was very important for the conclusion of the settlement. And in Europe, step by step, private enforcement is moving in the right direction. Patchy developments, yes, through a top-down approach, still through directives and regulations, whereas elsewhere in common law countries, in mixed system and in Latin American systems, the approach is more bottom-up, case law making the rules. The second lesson learned relates to the fact that developments are heavily uneven. And again, the Dieselgate is a striking example. Compensations in the US, less than 1 year after the scandal, ranged between $12,000 and $44,000 dollars, whilst in Europe, 9 years after, we're still struggling, and only a few member states have known settlements. Germany, the UK, Italy, and very recently Australia, but with far lower compensations in settlements, ranging from 1,000 euros to 6,500, according to information available. The third lesson learned, because class actions are globally established, from a policy perspective, we know exactly what it works, and we know exactly what does not. To get started, to open the doors of the prétoire, we cannot be naive anymore. Standards should be granted broadly upon strict criteria of representation. And the economic viability of the mechanism, either with public funds, legal aid, or with private funds, be that contingency fees, be that third-party funding, or by the force of law, like in the last Italian reform, are needed and indispensable. Efficient systems for work are those whose rules are purpose-driven. And since the purpose of class actions is access to justice, deterrence, and judicial efficiency, rules need to get towards those objectives. Therefore, there's no other option for compensation than to adopt the opt-out rule, or what we call in the Latin American countries the secundum eventum litis rule, that allows those who are related to the case to acknowledge the decision and enforce for themselves if the decision is favorable to the group. Notification mechanisms should be performant. Claims administrators should build on innovative technology. And to ensure deterrence, The judge must be able to assess the damage on a global basis. A non-recovered fund cannot be reversed to the defendant. They need to be allocated to a Cyprus solution or a flood recovery. And to ensure judiciary efficiency, there need to be resources. Judges need to be trained, they need to be skilled, they need to be proactive, namely in evidentiary matters, seeking the best notification possible and seeking the best outcome for the group and for the society. They need to be creative, the judges, but we need to be creative as well. The strategy matters. We, the claimants, we, the NGOs, we, the class reps, we, the governmental organizations, we, the lawyers, we, the service providers, have to be creative. We have to build on experiences that function abroad, since we are responsible for proposing solutions to our judges. Fourth lesson learned, details matter, and we know where God and devil lies. What happens in countries where there's no class action, or where there's no class action, like in Peru, where the class action is inefficient, like in France, or where it is efficient in the shelves but not in practice, like in Brazil? What happens is either there's no litigation at all, and that it is unbearable because it leads to asymmetrical justice, or it leads to extraterritorialization of the litigation. And we are seeing this currently ongoing in environmental cases against super majors brought in the UK for the compensation of indigenous people after the Brazilian Maria Madame disaster. And the same goes concerning Peruvian populations after an oil spill case that is brought in the Netherlands. Fifth lesson learned. Since nowadays it's very easy to know what settlements are about here and there and decisions, asymmetrical justice has become unbearable. And to challenge the status quo, many of us are working and lobbying very actively. We, the stakeholders of the collective redress world, are no longer working in sealed compartments. We are working in a cooperative manner, and I see many friends and colleagues whom I'm cooperating with. We, the claimants, you know, I'm the president of an association, and lawyers, we are organizing ourselves in networks and steering our imagination towards key equivalent solutions in the different countries. The same is steered by the European Commission and by NGOs, some of them composing federations or umbrellas. For instance, the BERC, a European consumer umbrella organization, alerted the European Commission's violations by TikTok in 2021, by Meta in 2023, and last September of unfair practices in the video game world, Fortnite and Minecraft. This led to a German authority to sign a cease and desist declaration, and in the Netherlands, an action is pending as our association brought 2 actions against TikTok here in Portugal. We professors are training lawyers and judges from a comparative perspective. And the judges are using more and more the comparative reasoning, thanks to formal covenants and twining covenants, and thanks to networks like the network of judges in the European environmental world. According to interviews that I've had the pleasure to run with judges all around the world, I can share that they are all interested in what happens elsewhere, but they confess having no resources and time, no surprise. The higher the instance is, the most probably they have already had a documentary research on the decisions and settlements that have been brought elsewhere. And most of the judges I discussed with have checked what is going on elsewhere, both in civil law and in common law traditions, even if we know there's some reluctance in civil law countries to quote the judges, which does not mean that they have not read them and that they are not influenced by those decisions. So decisions are influential on other judges, but decisions are also influential in practice, as witnessed by the revolution in the third-party funding world with the Packard decision, with the Airbus or the TikTok decisions, the first in the UK, the second and third in the Netherlands. Consequently, class actions operate a convergency between traditions. And to conclude, on some future-oriented notes on the global class action world, I would like to say that class actions are here, and they're here to stay. I would like to paraphrase colleagues from a top-tier American law firm I work with and say that class actions are here to make the system, not to break it. The interconnected nature of the globalized design and production of our world is a double-edged sword. It has led on the one hand to democratization and access to goods and services across the globe, and yet complex problems arose and arise that have a global nature, and we need to cope with them from a global perspective. Class actions are here to enforce rights. Class actions are here to enhance compliance and sustainable practices, ESG accountability. In Europe, up to date, the process of implementation has been worryingly delayed. So far, little has changed. 22 member states have transposed the directive fully. 3 have transposed it partially. Only 2 are still lack a transposition. Notwithstanding, dramatic disparities remain because of the massive choice of the opt-in that does not work in European countries, and because of the absence of rules ensuring the economic viability of the representative actions. Moreover, discrepancies will remain because of a high number of soft law rules in the Representative Actions Directive. Those regarding opt-out, those regarding funding solutions, those regarding assessment on an aggregated basis and allocation of undistributed funds that have led to very discrepant implementations across Europe. Hence, in practice, in countries where the practice of collective redress was dormant, the situation might remain the same. They might remain rather undeveloped. Whereas the European hubs for collective actions confirm their roles as frontrunners. Of course, we are all very excited with the situation in Spain, and we are eager to see if they will join the triptych that we know as frontrunners in Europe. Looking ahead, the fitness check announced by the Representative Actions Directive is given a central role to the potential need of a European ombudsman to help enforce European provisions. But on the review of the Representative Actions Directive, which needs to be done 5 years after the text's adoption, but the European Commission says it will wait a little bit more, we shouldn't miss the opportunity to address European-wide problems with a European-wide solution. First and foremost, the definition of cross-border representative actions needs to be changed to encompass cases where qualified entities seek the representation of consumers of multiple member states or de facto of all the victims across Europe that are concerned by the infringement. For a cross-border representative action to achieve its purpose, the coordination of European entities enhancing European judges' network is necessary. A cross-border appraisal also requires addressing issues of applicable law to avoid the myriads of national substantive laws we are dealing with in our international cases. To smooth out the mission of delivering justice, jurisdictional matters are of the utmost importance to avoid forum shopping and to avoid the congested domestic tribunals of the handful of member states currently adjudicating collective actions. In sum, cross-border infringements require cross-border solutions, as the global infringements require global justice considerations. Absence universal, absence international, absence European jurisdictions, the domino effect of class actions spreading from one country to another simultaneously or consecutively implies re-territorializing, the global. The idea I'd like to convey today is that the global collective redress we are living requires a collaborative spirit and some sort of judicial cosmopolitanism. I chose very difficult words to end my presentation and to show that I'm an Argentinian living in France, working in Portugal and the Netherlands, and English is not my mother tongue. Thank you very much for your attention.